For more on this verdict and to dig a little bit more into the legalities of everything, I want to bring in Adam Kaufmann. He's a former assistant district attorney with the Manhattan District Attorney's Office. Michael Veen, a former Trump lawyer and criminal defense attorney. And Lanny Davis, Michael Cohen's former lawyer and legal advisor. Lanny, I'm going to start with you. Have you had a chance to speak with Michael Cohen tonight? And even if you haven't, talk to us about his headspace. He was called the greatest liar of all time. He was trashed by the Trump defense team. And he stood there for hours testifying. What does today mean for him?
So, first of all, I haven't talked to him. I'm no longer his lawyer, and I want to focus on the evidence. But I have said many, many times, Michael Cohen was found to be truthful under tough cross-examination in front of New York Supreme Court Judge Engoron in the financial fraud case. And the judge wrote that he was credible and truthful. And the tactic of using the entire defense to shout names in a courtroom when they're not evidence and not provide any counter to documents that do not lie means that this verdict was a verdict based on the facts and the documents.
Michael, you represented former President Trump. You worked with him. How hard is it to work with him? Because some people have said that Todd Blanche, you know, he had a case to present to the jury, but he also had a case to present to his client, former President Trump, and that can be difficult.
Yeah, you know, I'm not sure how much I really make of that. My experience was that he was a very good client. He was easy to work with. I found him, first of all, to be a pretty humorous guy. He seemed intent on giving you what he thought were the important points that he wanted to make, but he gave us a free hand both in the impeachment trial and then in the Manhattan trial.
Well, I ask you about that because some people said that maybe Blanche had some missteps in the closing arguments and bringing up people like Bob Costello, in trying to relitigate Stormy Daniels. Those were missed opportunities.
You know, I don't know. I thought Blanche did a good job. I thought, you know, I thought he's a very good lawyer. I think he did a good job. And frankly, this is a historic trial. What he was able to accomplish in this trial was much more important to him than, am I going to get another case from Donald Trump? I mean, he's in the history books.
But he lost the case.
He did lose the case, but he defended the case in a way that I think was probably much more motivated by what's the best defense that I can put on rather than, hey, I'm going to please my client. You know, we all usually have conflicts with our clients, and, you know, and there are a lot of disagreements. But there are only two decisions in this case that were Donald Trump's and Donald Trump's alone, and that was to plead not guilty, and that was to testify or not. Otherwise, you know, he has input into the case, and the lawyer has input in the case. Those are his decisions, and, you know, that second decision probably had an effect on this trial.
Adam, was this case winnable for the defense?
It's really a hard case to win. I mean,
but it's untested legal theory.
Well, but that's a different issue, right?
Yeah.
There's the issue of it's an untested legal theory. The jury doesn't know and doesn't care that it's an untested legal theory. They don't know that. What they hear is the evidence in the courtroom, right? And you look at the documents, and you know, and I agree, Cohen was well corroborated, and that's so important in a case like this. But so the legal theory, the untested nature of it, that's going to be an issue that might be hashed out on appeal, but not in the courtroom.
Yeah, I'm just trying to understand because, you know, in looking at this case, there were key witnesses that never showed up to trial, that were never called by either side, including Alan Weisselberg, the man. Go ahead. Well, go.
Well, Weisselberg testified in our trial. Weisselberg didn't testify because Weisselberg has showed 100% support and loyalty to the president. So he wasn't going to take the stand and say anything that the prosecutors wanted the jury to hear. Weisselberg was gone to jail twice for his loyalty and would have been willing to go a third time if somebody thought again, oh, he perjured himself and we're going to charge him again.
Lanny, you worked with Michael Cohen. You were his lawyer. Michael Cohen obviously has a reputation that can be debated by both sides. Do you think that Michael Cohen has finally sort of received justice? I mean, he did hard time. He defended Donald Trump till the end until he didn't. His family was put through so much, and now Donald Trump is a convicted felon.
Look, I'm a former lawyer for Michael, so I just have to follow certain rules and not comment about Michael. But I can say what I've previously said. Every word that he testified to was backed up by documents, including Mr. Weisselberg, who wrote down $130,000, multiplied it by 2, to take care of income taxes. And yet Donald Trump's defense was that number was legal fees. If you lie about that number being about legal fees, when everybody, certainly the jury and everybody knew that number was about Stormy Daniels, that's the end of the defense. You lie about legal fees, then the conspiracy can be believed by the jury that he knew he wasn't paying legal fees to Stormy Daniels. He lied and recorded them as legal fees. That, to me, is the logic of the jury looking at that document, and that document speaks for itself. And Weisselberg was the most important witness against Mr. Trump because of his own handwriting and what I just said.
Reasonable doubt. They needed one juror. They couldn't get there. I don't know if you can describe the jurors getting to this verdict in a fast manner. It seemed fast to me. I didn't go to law school. And I bring all this up because it sounds like the prosecutors convinced the jury easily. I mean, because they got back, they wanted to hear the instructions once again, and it was unanimous on all the counts. And so my question to you, Adam, I mean, like, did the defense, because you guys were talking about the defense, I mean, was the case winnable, or was it over from the get-go?
Look, anytime a criminal case goes to trial, as defense attorneys, we know it's difficult for the defense. The prosecution gets up there, they put on their case, and most criminal cases that go to trial end up as convictions. The prosecution did a great job. I think there were some missteps by the defense. I think that I would have talked more about the fact that Weisselberg wasn't called. Why wasn't he called? He's the one, right? I think that putting on, one thing to think about is the defense doesn't have any burden. And so they can sit back and do nothing and just poke holes at the prosecution's case. When they put on a witness, now it gives the jury something to balance, something to weigh. And so if you're going to put on a case, it's got to be more than Costello. Right. Because now you go from having nothing and the jury just has to focus on the prosecution case, and then you put something up there, it's so feather light that now the jury is weighing the two sides.
Michael, would you put up more of a defense?
Witness-wise, you mean?
Witness-wise, case-wise, I mean...
probably not. Generally, in a criminal defense case, it's the government's burden, and you don't put on too many defense witnesses. It's cross-examination. We make our living on cross and closing. We don't do a lot of direct examinations. But I want to tell you, a year ago, we did a mock jury trial on our trial, and we did deep-dive jury questionnaires and evaluation of the Manhattan jury pool. 8.5 out of 10 people had very strong feelings against the president. The other 1.5 just didn't like him. So
it was hard to win a case in Manhattan, is what you're saying? Yeah,
it was hard to win a case in Manhattan, but I have such faith in the jury system. I mean, it really is the best system that we have. And I'm a little disheartened because the presumption of innocence and that guilt beyond a reasonable doubt, from when it was first written to where it is now, is really eroded.
Does he have, we only have 30 seconds, does he have a chance for an appeal?
I think he's got a couple issues on appeal, absolutely.
Yeah?
Yeah.
In the jury instructions, probably there's some issues on appeal, some of the trial evidence that came in. There's a couple of issues there that will be interesting.
Okay, guys, we thank you so much for being here.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.